All right, ladies and gentlemen, continuing on now, we're going to roll into our labor and employment aspects of this niche industry. Top 7 wage and hour mistakes for quick service and fast casual employers to avoid. Joining us today is Mr. Ted Bowen. Ted is a partner in the Fisher and Phillips law firm out of the Atlanta, Georgia office. Yes, he offices with Andrea Ryan, who many of you have seen at our programs before. Ted's practice, he represents employers in all areas of labor and employment law, but he has a special focus on wage and hour compliance. And he and the team out of the Atlanta office, as well as the nationwide Fisher and Phillips firm, have a significant number of hospitality industry clients, and we refer folks to them frequently. Ladies and gentlemen, please welcome Ted.
All right. Thank you, Stephen. I appreciate that. And yes, I'm going to be discussing 7 common wage and hour mistakes that occur in the hospitality industry today. I think an alternate title could be No Good Deed Goes Unpunished, because many of these mistakes are born out of good intentions. But unfortunately, the FLSA, the Fair Labor Standards Act, is a very unforgiving law. And there are serious consequences for these mistakes. The first one is going to be talking about tip jars, but I'm going to be referring to tips periodically during this presentation. The tip credit has been an area of intense agency regulatory activity in recent years, and the Department of Labor has made it very difficult for employers to use a tip credit in recent years. There's a lot of onerous limitations that have been applied. I'm sure everyone on this call, or many people on this call, have heard of the 80-20 rule, which is very difficult for employers who have tipped employees because it creates these obligations to track the specific duties being performed by your tipped employees. I'm not going to get into 80-20 in depth here. That is a topic that warrants its own presentation at another time, but I do just want to mention it. But let's first talk about a tip jar. Some employers have a tip jar and might be tempted to use the proceeds of a tip jar to give to a charitable entity, some sort of donation, which is a good thing in theory. The problem is that tips belong to employees who earn them, and employers are prohibited under the FLSA from keeping tips or donating them on the employee's behalf. So a better way, a better alternative to unilaterally making a decision to donate the proceeds of a tip jar to a charity would be to set up some sort of method that allows your employees to voluntarily contribute funds to an employer-sponsored charity, and then to have some sort of sign-off demonstrating that they did consent to that sort of contribution. Marilyn, next slide, please. All right, another area where we've seen a lot of regulatory activity involves managers and tips. And the Department of Labor prohibits managers and supervisors from participating in a tipped pool. And the test they use is whether or not the employee would satisfy the job duties test for the executive exemption under the FLSA. So is their primary duty management? Do they regularly supervise 2 or more full-time employees? And do they make hiring and firing decisions, or do they make recommendations that are given considerable consideration? So your policy, if you have a tip pool, your policy should strictly prohibit managers and supervisors from participating in the tip pool. The problem that arises is with our tight labor market over the last couple of years, oftentimes we've had situations where team leads or shift leads or assistant managers will sort of wear 2 different hats at different times in the work week. And at times they might work as a server. And the question arises, can this individual participate in the tip pool when they're working as a server? And that's really a gray area, and it's an area of considerable risk. This has come up in Department of Labor investigations. It's come up in private lawsuits. It's very difficult for an individual who has managerial responsibilities to sort of turn off those responsibilities and clock out, so to speak, of a managerial role. So does that manager perform any managerial duties even when they're working as a server? Do the other employees in the establishment look up to them for authority and for work direction? So if the answer to those questions is yes, even if this individual is clocked in as a server, then I think you're inviting considerable risk by allowing that individual to participate in a tip pool, even if they're working as a server and participating only under those server hours. All right, another mistake that we see sometimes here, born of good intentions, is allowing back of house employees to participate in the tip pool. That sort of helps camaraderie in the workplace, to allow dishwashers, cooks, etc., who are back of house to participate in a tip pool. And it allows them to take more money home if you allow them to be in a tip pool. Unfortunately, if you are taking the tip credit for your servers and front of house employees, you are prohibited from allowing those back of house employees to participate in the tip pool. But if you don't take the tip credit for your front of house employees and you pay them at least the minimum wage or higher, then you are permitted to allow those back of house employees to participate in the tip pool. So the key here is, if you want to include those non-traditionally tipped positions in a mandatory tip pooling arrangement, whether for workforce morale reasons or to increase the amount of take-home pay that those back of house employees have, and to simply to reduce your labor expenses, then you should not be taking the tip credit for your front of house employees in order to have that type of non-traditional tip pool. All right, requiring your smoking employees to clock out for a cigarette break. Many employers receive complaints from non-smoking employees about their coworkers who are taking cigarette breaks. And there is something at a certain level that does seem unfair about that one type of employee is taking more breaks than others in order to have to smoke a cigarette. So some employers might respond to those complaints by saying, hey, smoking employees, if you want to take a cigarette break, that's fine, but you're going to have to clock out for that break. The problem is, under the Fair Labor Standards Act, short breaks that are between 5 and 20 minutes in duration, those have to be considered hours worked and must be compensated. So you're violating the FLSA if you tell your smoking employees that they've got to clock out for cigarette breaks of that duration. A better approach would be to tell your employees they're not permitted to take those sorts of smoking breaks outside of any other sort of set breaks that you set up as an employer. That way, you're limiting when they're taking their cigarette breaks, and you're not creating this sense of imbalance amongst your workforce. Next slide, please. Okay, another good intention type mistake here that we see pretty often is not including bonuses in the regular rate of pay for your hourly non-exempt workforce. So let's say that you decide to implement some sort of bonus program that rewards your non-exempt employees, your team leads, for hitting certain performance targets, whether it's based on sales or some other criteria. You're trying to do something good for your workforce in that setting. You're trying to incentivize good performance and then rewarding it when it occurs. The problem is, under the FLSA, you have to include those sorts of payments in the regular rate calculation, because otherwise, if you don't, you're not calculating and paying overtime correctly. So if you want to set up that sort of bonus incentive pay program, you need to make sure that you are including those types of incentive pay into the regular rate calculations for those employees if they are working more than 40 hours in a work week. We see this time and time again. There's this misconception out there and myth that bonuses don't have to go into the regular rate of pay. That simply is incorrect. Only discretionary bonuses can be exempt from the regular rate, and non-discretionary bonuses, which is the vast majority of bonuses, has to go into the regular rate of pay. So again, if you're creating that sort of program, make sure that payroll is capturing that and including it in the regular rate calculation. Okay, so another mistake that we're seeing here is something that is becoming an increasing topic of conversation for hospitality employers, and that is, do we want to shift from the tip credit model to a service charge model? The pros of doing that are, if you're no longer taking the tip credit under the Fair Labor Standards Act, and instead you are implementing or assessing a mandatory service charge to your customers, by doing that, you're no longer required to comply with the 80-20 rule or any other rules that are associated with the tip credit under the FLSA. So that is a big administrative boon to you as an employer to not have to deal with those rules any longer by using a service charge. However, if you do that, service charge distributions to employees are not tips. And while tips do not pump up the regular rate of pay for overtime purposes, service charge distributions do. So you need to be sure that if you move to a service charge model and you decide that you want to distribute those proceeds to your employees moving forward, you need to make sure that those distributions are being captured in the regular rate calculation for your employees if they work more than 40 hours. Now, I will tell you that there is a potential overtime exemption, the Section 7I retail service establishment exemption, that could allow you to use the service charge model and to no longer have to pay overtime to employees. But that's a pretty nuanced conversation that you're going to want to have with your attorney if you decide to go down that road. I just want to make sure that everyone out there is aware that it does exist. But the takeaway here is, if you move away from the tip credit to the service charge model, make sure that those distributions are going into the regular rate of pay as long as you are treating those employees as non-exempt. All right, having your salaried exempt managers perform hourly tasks. We've seen this a lot during the pandemic and even since then with the tight labor market, where managers are increasingly being asked to do more than just managing. They are in the trenches with their subordinate employees, doing a lot of the same non-exempt type work that their subordinate non-exempt employees are performing. And while the FLSA does not determine exempt status based on the quantity of non-exempt work that is performed, it certainly is something that courts in the Department of Labor will consider in determining whether or not an employee is exempt or non-exempt in the first place. So, of course, to meet the executive exemption, the employee's primary duty has to be management of the establishment. And as I said, primary duty is not necessarily determined by the percentage of time spent on a duty. There have been plenty of cases where an employee's primary duty was only 20 or 30% of their total hours worked in the work week. It still creates questions and is something that's going to be a challenge for you in a litigation or a Department of Labor investigation. So if you're having your exempt managers perform hourly non-exempt duty type tasks, it's worth your while to sort of assess what percentage of time those employees are spending performing those tasks. And as you get higher, as that percentage increases, so does your your risk of having a potential misclassification type lawsuit. So periodically, review how much time is being spent on those tasks, just the same way as you should periodically review job descriptions to ensure that they're still accurate and reflect the work that is actually being performed by your employees. Next slide, please. So closing thoughts here. Again, no good deed goes unpunished. The COVID pandemic has created a lot of obstacles for employers in the hospitality industry. Good intentions really don't get you far with the FLSA. Maybe they could limit sort of liquidated damages or third year of the statute of limitations, but that's about it. One other point I wanted to mention, because it's becoming a point of emphasis by the Department of Labor, relates to child labor. And that is, because of the tight labor market, many hospitality employers have hired more minors in recent years than they might have in the past. And the FLSA has hours worked limitations for minors. They can only work a certain number of hours in school weeks. They can only work certain times of the day. And we've seen a big increase in violations in recent years. I think that the number of cases, if I'm not mistaken, it just came out, showed that the Department of Labor had something like a 10 to 15% increase in the number of child labor cases that they have been investigating in fiscal year 2022 versus 2021. The FLSA also puts limitations on the types of work that minors can perform. So for the hospitality industry, for example, minors aren't allowed to operate deep fryers that are manually operated. They can only work on fryers that have some sort of automatic lowering system for fryers. Meat slicers is another area where there are limitations on what minors can do. So I just want to highlight that for those of you out there who do employ minors, you got to be careful about hours worked rules, and then hazardous occupations or hazardous duty rules. And of course, remember that states often have their own wage hour rules that are more restrictive than the FLSA. All right, thanks, Stephen.
Hey, Ted, that was terrific. Sorry, I was on mute. Listen, that was terrific. I have a quick question for you. Again, I might put you on the spot with this, but going back to your mistake around forcing people to take their smoke breaks to clock out, right?
Right.
So, that does create challenges. I know I've heard from that. And as you pointed out, here's my question though. And this is probably state specific, like we learned, in a lot of cases, but can an employer today in many states not hire people that smoke? In other words, can we legally discriminate against people that smoke and vape?
There's nothing in the Federal Fair Labor Standards Act that addresses that issue, Stephen. I do think that many states have now, not many, I know some states have implemented restrictions on discriminating against employers based on that status. But yes, that is going to be a very state-specific inquiry, and it's not something that the FLSA governs.
The text, but okay, that's very helpful. And I assume the same response if I asked you about vaping, or yes. Same kind of thing, right? Because that's also becoming the issue as well.
Right.
Yeah, for sure. Wow, fascinating. All of your discussion around tip credit was illuminating, and I think you provided some excellent suggestions to people. So very grateful for the fact that you not only laid out the challenges and the mistakes, but provided the audience with suggested solutions. As you know, Ted, a lot of lawyers don't do that. So we're very appreciative of that. Tell everybody back at the Atlanta office, we said hi. We'll definitely have you back. Thanks for joining us today.
Thanks for having me.